our process of going through the various judicial-related offices and departments, and this afternoon we're going to hear from the courts, and we're going to start with the Court of Appeals, Judge Mary Eileen Kilbane.
Good afternoon, Mr. Chair.
Thank you very much for joining us. Welcome to the committee.
Good afternoon.
And Judge Patricia Ann Blackman.
Judge Patricia Ann Blackman.
I was going to get there. And Council President and the representative of the executive, Deputy Chief Cologne. It's an honor to be here today. Judge Patricia Ann Blackman will be the administrative judge in 2012. And also with us today are our court administrator, Uta Vilfoy, and our fiscal officer, Deirdre Taylor. I'm sure most of you know them. Just to give you a little summary about the court, we're made up of 12 judges. We're a state court. There are 12 districts in the state. We are the 8th District Court of Appeals. There are 68 appellate judges in the state of Ohio. And we're here today about our budget, as you well know. A little history that I think could be helpful. This process of transferring our budget from the county to the state began 10 years ago with the late Chief Justice Moyer. And 10 years ago, the county paid 80% of the Court of Appeals budget, and the state paid 20%. And through the efforts of the late Chief Justice Moyer, as well as all of the counties, there's been a gradual transfer. So this year, we're at 20%. We had a meeting on September the 14th, Wednesday, September the 14th, that the council president attended, as well as the fiscal officer, Wade Steen, people from Office and Budget Management, and other county people to talk about this last 20%. So while it might appear that the Court of Appeals has been dragging its feet, it's been very proactive. We called this meeting. We invited the county to come. We invited Chief Justice Moyer's executive director to be at the meeting. He was there. He traveled up from Columbus. And it was a great discussion, and we were moving forward. And where we are today about now being told that the state will, in fact, in 12 absorb has actually been with the tilling of the soil and the work that began over 10 years ago. So if you have any questions about our budget or anything that we can answer, we'll both be happy to do that.
Questions by any of my colleagues? Here's that we have no questions. Thank you very much for coming in.
Very good. It's short and sweet. Thank you.
Yes. Okay, next we will move on.
It's because Greenspan's out of the room.
Poor David.
We're also going to complicate his calculator over here.
Okay, let's move on to the Court of Common Pleas. We are honored to have with us Judge Nancy A. First.
All right.
Welcome to the committee.
Thank you, Mr. Chairman and Council. It's good to be here this afternoon. For the first time, we convened to undertake this new budget process under the new county government structure. As the presiding and administrative judge, I'm pleased to be part of this historical moment, as I was when you were sworn in these chambers some months ago. Let me introduce those who are with me in case we have any questions. I think that they are sometimes better prepared than I to answer, depending on how complex the question may be. But with me, I have my court administrator, Greg Popovich, Deputy Court Administrator Jim Ginley, and Maria Nemec, who is the Executive Director of the Corrections Planning Board. You'll notice on our number 3 on our submission to you, she may be able to answer any questions you have with respect to that, Health and Human Services. Let me address you first as the administrative judge of the Common Pleas Court General Division. You know that the Common Pleas Court really has 4 divisions, but you know also that we are the largest court in the state of Ohio handling civil and criminal matters. Last year we had over 50,000 filings combined, civil and criminal. And I just want to update you on some of the projects that are presently in process in our court. Number one, the adoption of e-filing system. We are now in the testing stage. This is not a reinventing the wheel. The federal system does it, but we will find that down the road there will be many savings, hopefully in printing, paper handling, swiftness of filings, et cetera, et cetera. So it is the way of the future, and we are moving in that direction in concert with the clerk of courts. So we are in a testing stage, and we expect that project to move forward. We are also planning to increase in our court committees, increase the security deposit for court costs so that the clerk of court can make refunds instead of billing people. So that will put more money to cover the cost of filings. Also wanted you to know that there are email notifications now instead of those postcards. For those of you who may practice law, years ago postcards were being sent for every journal entry or every docket entry. That is now being done by email at a much lesser cost. We are implementing evidence-based practices in the pretrial and probation departments. This is cutting edge, a huge shift in corrections and probation. You've heard from the state on House Bill 86 and also the Ohio Department of Rehabilitation and Corrections. They now want to shift the burden of incarceration, of concentrating our scarce resources on those who are in most need. And I'm happy to say that this project has been underway for a number of years now. We are now in the final stages of implementation. We have a pilot with 7 of the 34 judges presently working this, so we can work through the particulars and any of the glitches that we find. But we are a cutting edge in this program throughout the state, and they do look to us for our guidance. I think you will find that ultimately we will have a better use of scarce resources for supervision. Our early case management, this was alluded to by Prosecutor Bill Mason, is presently called EDC, or Early Disposition Conferences or dockets. It's the incorporation of the best of the traditional processes, criminal processes, and new ways at the early stages of a criminal prosecution. And this all is a result of the Justice Management Institute report a number of years ago. What it wants to focus on is early assignment of counsel and reducing the number of grand jury presentments. In effect, what it does is capture from the time that a case comes into our felony system to the time it's presented to the grand jury. We are capturing that time and trying to work out cases where they can be worked out in a more expeditious manner. We also have, and Councilman Gallagher would be very familiar with this, his sister Eileen T. Gallagher, who's a member of our bench, is our chairperson for the foreclosure department, but we boast a wonderful, nationally recognized foreclosure mediation program to allow eligible homeowners to stay in their homes if they can work something out. They try to bring in sources and resources for homeowners to use in order to do this. We have, in effect, with the blessing of the Supreme Court of the state of Ohio, taken our foreclosure filings. In certain cases, we have them worked up. If they are eligible, we then put them in somewhat of a box to try and do workout situations. And I'm happy to say that Judge Gallagher and Ms. Canast, who is in charge of the program, have testified in congressional committees. They're doing very well on that. We also operate and we have operated and will continue to operate specialty courts. The mental health docket is a very big one. There are 5 of our judges committed to handling mental illness, dual diagnosis, et cetera. We have drug court, David Mattia, and this is in concert with the municipal program. Reentry court by Judge Nancy Margaret Russo. She has her own reentry court. We also have judges who do judicial release. And then, of course, the commercial court on the civil side, which is in the pilot phase. And all of these are to improve the delivery of justice. what we have found, I've been on the bench for 15 years, what I have found now is the court is being required generally to do more, especially on the criminal side of things. Case handling has become more complex, but also we have become a deliverer of social services, say for instance the mental health and developmental disabilities, those who are involved in our system. Now, before you, I think we submitted a synopsis of the budget from from the Office of Budget Management, and a few adjustments that I submit for funding, which we deem reasonable and necessary for the effective operation of our court. And the justifications have been outlined there for you under each section. I think it's on one page. There are 3 of them. Let me address you as the presiding judge, which is a different job, more or less, than the administrative judge.
Judge, could you hold on just a minute?
Yes.
I don't think we have that document yet. Do you have it, Trevor? Okay.
Well, I'll keep talking and you'll have a chance to take a look then. As presiding judge, this is a position which involves the collaboration of the 4 divisions of the Common Pleas Court, and I am pleased to report that we have met, the judges in each division have met with regularity in the past year and a half, and basically we're a group of newer administrative judges searching for better ways to achieve our objectives and resolve administrative problems which are common to all our divisions. And that may entail disaster recovery plans, how we can take advantage of economies of scale to purchase legal research, supplies, interpreters, and we are fully engaged and confident that our continued collegiality and collaboration will produce some good outcomes here in the short run. And let me introduce to you, you will see them separately, Judge Palos from the Domestic Relations, Judge Russo from the Probate Court, and Judge O'Malley, of course, from the Juvenile Court. So with that said, if you would like just to take a moment to see what we have submitted, and I'll be happy to address any questions that you have.
Mr. Chair,
Ms. Simon?
can I proceed with a question?
Yes, you may.
Thank you very much, Judge, for your presentation. I wanted some specific information on the mediation department, and for some reason that's not broken out in front of me, which
there's no special request for anything. I'm just telling you generally what we're doing.
So how many individuals are actually employed for that specific department? Do you have...
We have approximately...
I'll let Jim. Jim is our deputy court administrator, and he handles most of the payroll. He's got a good handle on the actual numbers, which float to and fro.
Right, and Greg, absolutely in unison with the philosophy behind mediation and so on. Our foreclosure mediation program is funded primarily through special project fees, and that includes the director, our ADR director also kind of as co-directs it. They're on equal footing with it. We have some clerical staff there, and we have approximately, in addition to the administrative staff that has a docket, we have 5 other people listening to mediation foreclosure cases.
They're an extremely busy court. You can go find that on the 10th floor of the Justice Center, and it's been very helpful for many people. I'm not sure how many deferrals are in there at this point in time, but we are reporting regularly to the Supreme Court because they are very interested in the outcomes there. They have given us permission to do this with their blessing. So, and
Okay,
Judge Gallagher, as I mentioned, has done a nice job kind of directing that overall operation from the standpoint of the judges. So she reports back to us and keeps us abreast of any changes that we need to consider.
So, Mr. Chair, to the judge and deputy, is the Special Projects Fund part of the, does that come in through a filing fee? How is that, the Special Projects Fund funded?
That's accurate. There's actually a fee that's attached to each foreclosure case that comes in. These are not general fund monies in any way. We've chosen to not push that burden onto the general fund, and so we're using those funds to be able to fund this program, which enjoys over a 50% success rate in terms of the matters coming in before mediation. So whether it be a loan modification or there's some agreement going forward so that the homeowners can stay in their homes.
And a follow-up question, in terms of the foreclosure filings, is that, are the filing fee still $100 for the foreclosure filings, or are they same as civil?
They're actually, I'm trying to remember the total amount, but it's a $200 filing fee,
For
special project fee
foreclosure.
for the foreclosure
Yep.
fees.
Okay.
That's
and-
funding that. Those fees, of course, pay for a lot of different things in the county, not only for the county police court, but also for staff in the clerk's office and also for the sheriff's department.
But the regular filing fee for civil cases is $100?
$100.
But we're looking to, the court's looking to raise that.
Yes, there's a committee that's investigating and comparing. We're doing a survey of different courts throughout the state to be able to determine what the appropriate amount should be for a filing fee.
And when might that happen?
Hopefully, I would think, early next year. The advertisement, local rules, we would have to advertise. Then questions would come in from the public in regards to that process. And then it all is dependent upon those questions that come in. Do we go back out again for questions, that type of thing? We're hopefully early next year that'll be in place.
Okay, thank you.
We'll work with the Bar Association
Yes.
also, seeking their guidance.
Yeah, Mr. Chair, I just want to comment, I think we're low, and it's probably, the fee's been the same way for years. The civil filing fee, I think from when I started, it seems, but
We are de- yeah,
it's
we are definitely-
time to,
We are definitely addressing it. That will happen through the court committee, and that committee is working. So we should have something in the next few months.
Councilman Gallagher.
Hi, Judge.
Yes.
Number one, the reinstatement of vacancy rate. And this is in response to poor economic conditions. The economic conditions are still poor and getting worse. You want to go through that and tell us how that happened?
Yes.
I guess strictly from, and Jim can handle from a fiscal standpoint, but issue number one that's on your agenda, this comes about in our effort to cooperate with the county administration, whether that be the prior or this administration. We chose to hold a number of hires on our end of things. It doesn't mean we did not need the position in any way, but on our end of things, we agreed on a number. We're going to get to that number, and the plan was to be able to hold certain hires as a result of doing that. For the last several years, we've cut millions of dollars in our budget. We've gotten to our number every year to be able to do that. But to do that, of course, we had to do certain things on our end, not just with hires, but in a number of areas in our court. One of the issues that, of course, what happens is, we end up having a position open, and we choose to keep it open intentionally until we get that cost savings, until we can meet the numbers that we have agreed to meet in terms of our discussions with the executive's office. But one of the problems, when you get into that, of course, then our vacancy rate's going to go up. And so as a result, we don't disagree that there's a vacancy rate per se, but it's the rate or the formula used to calculate this amount we disagree with. It's been artificially and intentionally inflated due to the economic conditions. We have chosen to cooperate with the county and to meet those numbers. A number of positions have gone vacant intentionally on our end of things that are seriously impacting our court. I can give you one example. In the probation department, we have a number of supervisor positions that are currently open. A large number of vital positions, but these are also big ticket items when it comes to salaries. So to get to the cost savings in terms of the furlough, in terms of other matters that we agreed to get to, we intentionally kept those positions open. We are now, of course, posting for those positions. But to do that, we put what we call, quote unquote, lead officer people in place. So basically, I went to the chief probation officer and said, this is a number we're going to get to, and basically come up with a creative way of getting there in the short term so we can meet the numbers by the end of the year. So what we did is we intentionally kept those positions vacant. Doesn't mean we didn't need that position, but these lead officers are now not only have their regular docket of probation cases, but also are kind of a quasi-supervisor. No additional pay to do this. And doesn't mean that position isn't needed, but these people are taking on a number of different tasks as a result of that. We need to fill these positions. So and that part of that vacancy rate, again, is intentionally inflated. We will meet our number by the end of the year. And, but those positions were vacant because we chose to do that. And again, that's, so the vacancy rate is calculated at whatever arbitrary, I can't figure out what the number is. Maybe we can come to some agreement through discussions on what the number maybe should be. But at the end of the day, to indicate that these jobs are not important and we should not fill them, that's a concern on our end. So, and certainly affects our court operations.
So to get to your number that the county gave you, you chose to go this route.
The way the number was calculated, they took, the Office of Budget Management took out the positions on the vacancy list, applied to them, and then took 65% of the annualized salary and then put that back into the budget. The 35% is representing the totals on your sheets that we just passed out.
I'm not denying that there may be some intricacies involved with the way in which they got to numbers, but the way in which they got to numbers was used across the board with everybody. And to argue that these are important jobs, which I don't doubt that they aren't important, there are other agencies in the county that have been just decimated, literally decimated as far as employees, Children and Family Services, things like that. And these are bad times. I mean, it's no better this year, and it's going to be no better next year than it was last year.
Right. Our duty, number one, we have mandates this year, September 30th, effective September 30th, which we did not have last year. And we've also been cut. We lost the use of 20 pre-sentence writers, from which were funded by the state. They completely, 28, I stand corrected, 28 pre-sentence writers, which were paid for by the state. They completely took that off our books. We used to get the money from them, and they used to provide that service. We still need the service. In fact, with evidence-based practices, which is being mandated, we need them more than ever. They gave us back 8.
Well, the hard reality is that the federal government has no money, the state has no money, and the county's walking on eggshells regarding this budget. And we're at the point where you're squeezing the turnip. And not just you, everybody. So I just want to let you know that, I wouldn't hold out too much hope that we have the money to cover this.
All right. I don't agree. We need this. The state has abdicated. What the state has done is shifted the work that it used to do for this county, and the work is no less. In fact, I would argue the work is more. We also need folks to, especially in probation and pretrial services, because the state is no longer allowing us to ship them out of here. They're telling you are mandated to keep your criminal population here for the most part. And that is a huge, huge impact on what we need to do. That also plays into the Health and Human Services number 3. We have to find, the new law says you need to find local places, which means we aren't even up to speed in our probation department. We're not even there where we were before. And we are being asked to do more by a mandate. It's an unfunded mandate. I don't know how else we can accomplish this.
Well, we'll get through it.
No. Well, that's why we're here asking for this, and this is not more, this is not extra, this is just give us our full complement. If we have savings that are incurred, or if, we have been very good stewards here. The Court of Common Pleas never took a buyout. They have allowed natural attrition here, and we run pretty mean and lean. I invite you to come over. I'd be hard pressed to say that these are not required. We wouldn't ask for them if we didn't.
We're hearing the same thing.
Yeah.
I'm just saying, we have to be careful ourselves.
Yes, but please know, these are unfunded mandates from the state government. They've cut. You are now county. are responsible, as we are, to place, incarcerants and offenders either on probation in some way, shape, or form. And that's in fact, I would say that's the bulk of what you're looking for right here. Court services and court psychiatric. Judicial administration, I mean, if we get any leaner, when we three aren't there, there's no one, okay?
Right.
Just so you know.
It seems Columbus
Yeah.
has shifted everything, so,
Yeah,
thank you.
all right, very good. Yes,
Council President Connolly.
Mr. Gallagher may have asked this question, but I was out of the room actually dealing with some other issue. But what is the amount over and above the figure that the county executive put in the budget for the common police court that you are asking? Is it 830?
it would be whatever's on that front sheet, the reinstatement of the vacancy rate, which is 519.
519. and
Plus
then-
fringe benefits.
And
Right,
then,
that has to be recalculated in the program.
Yes.
And then $111,000 in court services.
Plus the 111,000?
yeah,
Yes.
that,
Plus
and that is that is really not something that we will see. That's a system benefit.
So it's roughly $900,000, so over what?
Well, the 200 at the bottom is
Plus
levy
fringe.
funding, yeah.
That's levy, yeah.
Okay, so
Number 3.
630.
And that's also important because from what I argued in the first part here, and Maria can speak to that as the Correction Planning Board exec, we have to find places. We, as I mentioned earlier, we are the delivery person of social services like never before, and the law is telling us that we have to find somewhere local. Otherwise, we have to ask the state, and they'll sit in jail for 45 days for the state to tell us, put them in your own place here. So it is a difficult time, but it's a difficult time all the way around because we have a mandate to follow. Maria?
Especially at risk is the misdemeanor population. Due to the fact that we're all suffering from lack of funding, the state has reprioritized their needs and what they're going to fund. In the past, the state did allow us to use state-funded beds, halfway house beds, for misdemeanors as well as felony offenders. At this point in time, because of their dwindling resources, they have allocated those funds to only felony offenders. So those misdemeanors, and we placed over 400 of them last year, those misdemeanors that require residential treatment placement will no longer be eligible for funding under DRC. And I would like to say that we have done a tremendous job, I believe, in leveraging resources in the community and with the state. Last year alone, we have utilized over $3 million worth of state-funded halfway house beds, over 96,000 bed days, that were specifically allocated for the Adult Parole Authority to use on their parole population. When those beds are below capacity, through a lot of work and collaboration, we have been able to utilize those beds. Now, those beds will not be available to us for close to 400 misdemeanors that will sit in our county jails at the cost of $81 per day, waiting for treatment if they have no substance or if they have no mental health and or developmental disabilities. Those that do cost the county jail approximately $200 per day to sit there and wait for a treatment placement. So it's imperative, as the judge said, to look at the mandates that are being placed on us with House Bill 86, and if I may also add to the fact that we lost pre-sentence investigation writers. Not only is that capacity lost and we have not been able to recoup the entire 28 personnel, what we are also mandated now from the state is to do an ORAS risk needs assessment tool. That tool in and of itself takes about an hour and a half on top of our normal pre-sentence investigation time to do. That is now a mandated requirement that we do on all our high-risk offenders. So there has been a lot of emphasis on, and it's proven that it does work. We are really allocating resources to the high-risk, high-need. Through evidence-based practices, we are allocating supervision accordingly. Lower-risk offenders get a different set of supervision requirements. High-risk offenders certainly report more and get more intensive services. So as these type of services are mandated by the state, we don't have an option not to meet that mandate. We are also told by the state, or required, that if we don't reduce prison commitments by X amount, we will no longer continue to get CCA funds. And right now, we process, I think we get over $5.3 million in Community Act corrections funds. Those funds are all at risk if we do not meet their guidelines as to how many offenders we must keep in the community and how many offenders we must reduce from sending back to prison, even in technical violations.
Councilman Greenspan.
Great, thank you. Here's what I think we're going to face. All right, we're going to have groups like this come before us with the expectation, based on the information that's been disclosed publicly, that the county has experienced all these savings in the first 8 or 9 months of this year. Although the county may have received some savings, they're not net savings. And so you're coming here reading in the papers, the county saved $4, $6, $8, $10 million through all these cutbacks in costs, and although those statements may be true, the fact that our federal, state, and local revenues are declining, the decline in the revenue exceeds the savings. So what you're going to start to hear is not that we're hoarding cash, but that it's not what I think the public perception and reality are a complete disconnect right now. You've got some tough mandates that you've got to fund. We've got the job to try to do what we can to make sure you have it. But I also think it's important, and I was just able to get my arms around why everybody thinks we have all this money, all these savings that have been promoted.
Well,
They're not.
I must say that we never discussed that in our submission to you. We never talked about a pot of money anywhere else. We're just talking about what is necessary for the operation of our court, and here it is. There are three things beyond what the OBM. But that discussion never.
Well,
was had by us.
I think it's important for us to understand that the savings are completely wiped away by the reduction in income. And so and this budget here does not include anything that we saw from the prosecutor's office, or that we saw from the public defender, or that we've seen this request. So any of these requests are going to come off the bottom line, which we're already dipping into our reserves to balance this budget, because it doesn't balance, because our revenues are down and our savings don't compensate for that number, for that decline. So we've got a tougher job to do than I think people really understand, because the savings net are not there. I hear everything you're saying. We've got to figure out how to make it work. And this budget is going to get skinnier.
Which budget?
The county budget in total. We've got to figure a way to do everything you're mandated to do. We've got to strip out the wants versus the needs.
Okay. Well, there aren't many wants in here.
I understand. No,
In fact,
I'm supporting your position.
If I wanted something, I would, the cost of living, just things that Prosecutor Mason talked about, in all fairness. No one's seen a raise in our place, or a step, I don't know about a step increase, but no one's seen a COLA, anything, no one's seen any of that stuff.
No, Judge, I'm supporting your position. I'm saying you have definitive needs. We need to strip through the budget and understand the needs versus the wants, and really be prudent in understanding, is a need really a need, or is it a want? And that's really going to be our challenge when we go through the process. And I believe the chairman has set aside a few days for us to really deliberate on this. But this is a more daunting task, because
Well,
of
I don't
perception.
envy you, but please know that we thought long and hard. We played with this and had discussions with OBM and talked. This is what we are submitting to you as necessary. As a separate branch of government, this is my duty to present this to you, and I think I've done this after great thought and discussion with, those who are involved here and then the mandates that we have. So if you want a wish list, I really got a great one for you, but.
No, we're not asking for that.
I didn't give you that one.
No. I just want,
Right.
my comments are more to the committee that we need to understand that these savings are not,
Right.
they're
I
not
think-
net savings.
I think the thing to understand about some of the expenditures that we have, particularly when you look at probation, the big part of that, number one, is that if we don't perform, we lose the alternative funding. So it's almost penny wise, pound foolish. You find the same with mental health spending. Bill Denahan and I have had many discussions, in fact, testified in Columbus about, having certain funding and things available at the front end, and that's how we base this budget request. So,
Judge, could you amplify about item number 2 as to,
I'm going to let Greg Popovich
Okay.
talk about this.
just want to understand.
And the reason I defer is they are much better to explain.
how-
I know what it is, but they explain
how
it
it
much better
works
than
and
I.
what it would accomplish.
Sure.
I was hoping for a question actually on number 2. So anyways, in regards to number 2, talking about cost savings, I think long-term, you will get cost savings from item number 2. Currently.
First of all, just explain what it is. I don't really understand how
every
it
time-
works.
By the way, when we put that in there, I told him that he would have to explain that to you.
That's
so.
okay. This is a system benefit request. It actually, in large measure, doesn't benefit the Common Police Court General Division much. It actually benefits all the other agencies and also the Court of Appeals. Currently, when a transcript is ordered, it costs $2.25 a page to produce that transcript. It's what the court reporters, that amount was set years ago, probably decades ago, and in regards to the amount that the court reporter required and have agreed to pay the court reporter over all these years. They have not gotten an increase. I couldn't tell you the last time that occurred.
And who pays that fee?
The court does out of our budget.
Indigent.
Oh,
For
okay.
indigent counsel.
Indigent, yeah.
These are all for indigent, I'm sorry, these are for
I
indigent
see.
transcripts. And then if you want a copy, that being, so there's an appeal, and if you want a copy of that transcript, then you have to pay $1.70 page. That's something that was put in place some time ago. And so what we're looking to do is combine those two and actually be $3.25 a page. And we would offer free copies to the prosecutor's office, the public defender's office, and actually the Court of Appeals would get electronic transcript. Right now, we give them, for the most part, paper. And then they got to go through it. And so if someone has to cut and paste, or if they basically have to type it in, those type of things. What we're envisioning to do here is actually create electronic transcript, one that is able to be searchable. You can cut and paste from it, so attorneys can actually take a piece of that transcript, put it into their brief, and then move on, rather than having someone type the thing up and those type of things. But to do that, we had to agree with basically the court reporters to be able to offer that free copy. And the agreement came to the standpoint of the $3.25. How do we get to that figure? We actually did a survey of the different courts throughout the state of Ohio to determine what they charge for their different rates for the original transcript and for the copy of the transcript. For instance, I guess, let's see, federal court's charging $3.65 a page, which is the original in electronic format. $4 a page in Hamilton. I'd be glad to supply the survey to you. What we did is we took the average, the state average for the cost for the original and the copy, and that's what we set the rate at. To do that, based upon our current usage of transcripts, that's how we got to the 111,000 figure. Whether that ends up being reality or not next year, we couldn't know. It all depends upon how many trials that we have and or how many appeals that we get from our cases. There's no way really to know for sure what the cost will be. But what we will be able to do is now provide to, through our ProWare through CJIS system, they can go to the case and they're going to see a little, basically this is what we envision anyways if this is approved, that we will be able to put out there, here's the transcript. They can click on it. If they're working at home, they don't have to carry those big, huge docket or transcripts home with them. They can now do work at home, go to our website, be able to go in there through the portal that we're going to designate, and be able to download that transcript wherever they are. And it's searchable. It's something that we see as a benefit more so to the bar, that being the Public Defender's Office and the Indigent Defense Council, and then really to us as a general division. We think this is a good thing. I think in the long term will save money. Right now, I don't know to what extent monies are being paid in the Public Defender's Office and or the Prosecutor's Office or different areas for copies of transcripts. But the great thing on our end of thing is it won't matter. The bottom line is all those costs hopefully will, whatever they are paying, will go away because we're going to be able to provide that free of charge to everyone. So we look at this as a system benefit, not to a benefit to the County Police Court. The programming to do this, we are going to take it on ourselves. We are not going to, that's not in this figure. We're going to absorb that cost to be able to provide this on our end of things. And again, all the technology and all of the programming we have agreed to maintain, and the county will not bear any expense of that. They're only going to get the benefits in the end. So anyways, I don't know if that answers your question on that one.
That does. Thank you very much, Councilman Rogers.
Thank you, Mr. Chairman. Thank you, Judge, for your comments. And you mentioned in your opening statement that the court is more and more becoming a social service provider. And I have a couple questions based around that. And the first, you have a total full-time employees listed, 448 in 2001, looking to bump that up to 464. Of those employees, how many of those would you say are in the social service side?
In the probation, pretrial services, those areas where we need, and probably in the clerk. I'm going to defer to Jim. These really are not, when they hit full FTEs.
They're rolling from the register and they're taking the hourly count. They're taking 2,080 hours and turning it into one unit and calculating that. When we have part-time people, we have obviously full-time people, we have some interns. The probation department, I would classify as a social service agency.
Absolutely.
Pretty much.
And the
So that's,
pretrial.
yeah, and that's probably about 135 people.
Right.
Or
And then
more.
we also have a psychiatric clinic, which has how many?
Probably 20 people. We have a lot of part-time psychologists and a large number of part-time psychiatrists, as well as a full-time administrative staff that evaluates individuals. It's a working area with 3 social workers and about 4 full-time typists who are typing evaluations constantly.
So close to 30%, you would say, of the?
Probably more, probably 40%.
Are there, I'm just looking at some of the stuff that the county provides through Health and Human Services, and I'm wondering if there's any overlap between services that the county currently provides and what the court is either provides on its own or is mandated by the state to provide.
Services that the court provides through our probation officers are more direct service with our defendants, with our clients. They provide some counseling. It is certainly not clinical counseling. However, the state is now mandating us to do a complete risk need assessment, as I mentioned earlier, and also compile a case management plan. So they're looking at our officers as taking more of a social work role, or they're requiring us to take more of a social work role. Now, the monies that we are looking at with Health and Human Service are actually used for contracted services for sex offender treatment, residential substance abuse treatment, dual diagnosed treatment for our mental health consumers. So those are direct clinical services that are purchased through licensed, credentialed providers that are overseen either by the Adams Board or the Board of Developmental Disabilities.
Do we know, so I would imagine that, particularly if you're working with the Adams Board or even with any agencies of the county and contracting services, are there opportunities there, because we're probably contracting with the same folks, to kind of witness some discounts there, because possibly even doing joint contracts or?
Yes, our per diem rates are Medicaid rates. We set the per diem rate, so we do not go above and beyond. Any contractor that works with us really has this kind of a set rate. So we can maximize our beds, and we're very cognizant of that. We set the rate. We go out for an RFP, but we have a maximum per diem rate that we can afford to pay. We need a lot of services, and we cannot afford to do a huge per diem rate. And it's actually something that we've been called upon even several years ago, that we've been asked by the boards to really reconsider how much we're paying, because we're not paying enough. However, we need to maximize our dollars.
Do we know, just one final question, how people are being tracked? Because I would imagine that some people that find themselves in our courts may already be working with the county, with other agencies or other, receiving other.
Yes, and that's a good question. They're all tracked. All our referrals we work with, for example, we have a substance abuse case manager in probation who does all the placements for residential treatment. Prior to a residential placement, TASC, which is also under the court, Treatment Alternatives to Street Crime, conducts a clinical assessment. We get all the requisite releases of information to track to see what previous treatment agencies they've been in, how they've done, and that helps determine what level of care they'll go to, what agency they'll go to. And yes, we require all our providers to supply us with discharge summaries, so we can do follow-up to see how clients are doing, number one, and then how providers are meeting the needs of the contract.
And I'm sorry, that sparked another one. I look at some of the service that we're going to be, when we get to our Health and Human Service side, I'm looking at the Office of Reentry, and you made mention of the reentry court. Mm-hmm. And I'm wondering how they work together.
We actually work with the Office of Reentry, and we've worked with them since the inception, actually, of Reentry Court in 2008, I think. Office of Reentry, we've gone to them to help us with match funding. We started our Reentry Court through grant dollars from the Office of Criminal Justice Services, and we've had 3 years of funding from that office. And now the Office of Reentry is actually giving us funding to support one probation officer. So we work with them in helping to support the staffing of the court, not complete staffing, some of the staffing. And we also work with them to try to use and maximize some of the resources that they fund, some of the direct service, such as treatment. And I do want to say that, as I said it earlier, we are I believe we're very creative in using what's out there, so we're not duplicating and paying for services we don't need. We make sure that we access to recovery dollars. There are specific funds for specific populations, and if we have someone that meets that criteria, we certainly use that first. Our Health and Human Services dollars we guard, simply because they're really kind of our last resort. So we really guard that for those individuals that can really not meet other criteria.
Thank you.
Mr. Chair, I do.
Yes.
Thank you. I just wanted to follow up about the mediation department. I would like a breakdown of the salaries and the people. And when I hear success rate, I hear that, but I've also been through the mediation process. And success, does that mean that somebody has a loan modification and they're in their house for 6 months? That I'm not sure when we have mandated necessity like PSI report and all those things that are mandated. There is overlap, by the way, in that area of foreclosure mediation. There's several agencies that do a version of that outside of the court. So we do have overlapping. And I'm not really clear about the success rate. I'd like to see this.
Well, I think when they get to a certain point when there's actually, you may have bodies that engage in the mediation prior to a foreclosure filing. These are based on the filings.
I know.
And then the filings are then gone through. I think the beauty of the foreclosure mediation and also the foreclosure is they will expand and contract probably more quickly according to need than any other program that we have here, because if they aren't needed, we don't have people there.
So I still would like a breakdown of the salaries and.
Glad to do
Yes, we
Thank you.
can have that for you,
whatever
sure.
information you'd like, I'm glad to give it to you.
Because I understand the mandates now that have been pushed to us to handle, and it's really important, vital, that we have a safety net for the individuals who otherwise would have been cared for with the other dollars from the state, and that's crucial. I want to look at programs that are not crucial, important but not crucial.
We'll have that down for you later today. Okay.
Okay.
Is there anything
else?
further? There is one matter that does not relate to our budget, but I wish to just bring to the table. As you know, we are celebrating the 100th birthday of the Lakeside Courthouse. We have a committee up and running. I think that I might have sent a letter, Madam President, some time ago for maybe some action, just in support of those efforts, so that will help us obtain some sponsorships down the line. So.
I've been to a number of those meetings. I think Mr. Nani went to the last one. I was unavailable, but I don't know that we ever got a specific dollar amount. that
No,
there was-
no, we don't. We're not. I think we're asking you for some acknowledgement of the.
That's no, yeah,
group.
we'll get it done.
Yeah,
Okay,
yeah.
all right.
That's we're not asking for any money.
I thought we already did it, though.
Yeah, but if you have some,
I thought we did.
No, I thought, actually, I
Send it
thought
my
we already,
way.
the clerk tells me we already did that. I thought we already did the resolutions.
Oh, yeah, I have not received a copy. So if you would be kind enough to forward that to me for my records, I would be most pleased. Thank you.
Okay,
All
I'd
right.
just like to thank Judge First. She's been hosting all the meetings and doing all the legwork and bringing lunch and everything. It's very kind of
Right,
you.
right. And thank you for the time and effort. I know these are not easy times, and I'm very glad you allowed my support here behind me to answer some of your questions, because they are, dealing with it on an everyday while I oversee the general picture. So many thanks once again.
Thanks very much for coming in. And next, we will move on to the Domestic Relations Court, and we're honored to have Judge Diane M. Palos to represent that court. Thank you very much for being here, and
thank you
sorry you
very
had to
much.
wait a little while,
That's-
and welcome to the committee.
Thank you very much for having me. I also am proud to be here at this, I think, historic moment in our county, and I'm glad to be able to address you today. The first thing I wanted to do is just talk to you a little bit about Domestic Relations Court, because it's a little bit of a different animal in that we have what's called continuing jurisdiction. Domestic Relations Court handles all terminations of marriage, as well as all of the post-decree, that is after the termination of the marriage, enforcement and modification of all of the court's orders. We also do interstate enforcement of custody, interstate enforcement of support, annulment, a few other domestic. We have a huge domestic violence docket. Most of the domestic violence actions in the county go through us. So it's not just married people that file a domestic violence action in our court, but anybody who has lived as a family or is a parent or has a familial relationship with somebody. So there's a few other courts that do little bits, but we do the biggest share of that, and it is unfortunately our growth industry in the last couple of years. The other thing is, because of continuing jurisdiction, our docket is, the post-decree docket is significant. It's almost 2/3 or 3/4 of what we do as far as processing of cases, because children may be 2 months old when their parents are divorced, and we have continuing jurisdiction until they're 18 or graduated from high school, or until all the support is paid. So we have ongoing motions and a lot of animosity that continues throughout the lives of the children. And one of the things that we try to do is make a difference in that. Just to share with you, last year the personnel at the court got together and we did an exercise in which we wrote our mission statement. And understand that this was done at a time when all of our people were having furlough days, when they hadn't had a raise at that point for 3 years, when they were all told, you will do 2 jobs or you will leave. And we got together and we worked on this over a course of several months. We had a lot of people participate, and I'd just like to read that to you because I think you have to understand what we do is a little bit qualitatively different. The mission of the Cuyahoga County Domestic Relations Court is to help families restructure their lives by reaching compassionate and just resolutions to parenting and property disputes. We are very much about families and about protecting children, and most of what we do is mandated. Historically, we have had over 120 people at the court. Prior to the ERIP, we had 110 people. After the ERIP, we had 64. Of those 64, out of our 7 administrative people, 4 of them left. Of the 3 that were left, one of the administrative people had a department in which all of her department left. So I had no one but a department head. We have had to hire some new supervisors, some new personnel over the last 2 years. What we've been doing in order to manage that, part of that was managed because we had an agreement under the ERIP that we would be able to rehire some people who were supervisors, and part of it has been done because we have done everything possible to run as lean as possible. We have reviewed every single book and periodical that we receive, and we have stopped subscribing to many things. We have the cheapest Lexus contract of anybody. It's amazing how reasonable that is. It's like few $100 a month, less than that even. We have started doing email notices as of March, and that's been saving us a huge amount of money. We stopped allowing our copy machine to be used by lawyers and litigants and people who weren't even from our court who had just come to our court to use the copy machine unless there was a purpose for the copy. We've done all kinds of other things like that within our budget to save money. In addition, we've reached out to collaborate with the other courts. For example, when our social workers all left and we didn't have somebody to do home investigations, which is very needed in custody cases, we made a contract with probate court. They have some home investigators. We now charge a fee to the litigant who needs the home investigation. That fee is directed to probate court to defray the costs of their social workers that we are now using, and they write the report and send it to us. So we're doing all kinds of things like that. We've worked with, as Judge First said, worked with the other courts to look at other economies of scale that we can do amongst ourselves. We've applied for a federal grant under the Violence Against Women Act, and we received that, if you saw the newspaper, a $300,000 grant for 3 years to have support 2 employees to support our domestic violence docket, one an advocate and the other a case manager, to make sure that the orders of our court are followed through. And just as Judge First said, we are faced with presenting or providing much more social services in our court, more than most, because what we do is really about families and about children. We have reached out to the Cleveland Metropolitan Bar Association, and we have partnered with them for certain things. We have accepted externs from Cleveland State University and Case Western Reserve. Next year, we're going to have externs under the 3 R's program through the Cleveland Metropolitan Bar. All of these things we've done to try to save money, but at the end of the day, our budget is people and technology. And when I was made the administrative judge last year, we had 2 computer mainframes, one of which didn't work. Every personal computer that we had in our court was either 7 or 10 years old. We had less than $20,000 in our budget for computers. So we've been very slowly trying to do things to make ourselves more efficient. Every one of our people pretty much types their own things. We have one person who's designated as a typist, but she has 3 or 4 other jobs, and she only types some big projects for the judges, more memos and things, and she processes some of the orders for domestic violence. She does several, as I said, several other things. Every new person that we've hired has had at least 2 different skills that we've been able to use. Every person that we have has been cross-trained in their department or in 2 different departments so that they can support us, because you can't have 60 or 70 people doing 120 people's jobs without doing that. So what we're asking for, I think, is eminently reasonable. We're asking for what the Office of Budget Management provided, as well as 2 very small decision items. One of those is an additional mediator. This is another one of our economies that we did. We entered into a contract with the Office of Mediation, and we contracted for court mediators. What we're doing is we're paying a fee and having Susan Organischek, who runs the program for the county, provide mediators to us. This is really helpful for a lot of reasons, one of which is that there's a lot of confidentiality issues with mediators, and if a mediator has a problem, they need to be able to go to their supervisor. That supervisor can't be the same person who then would have the case as a social worker if the case does not resolve in mediation. So this having a separate entity doing the mediation really makes our mediation project a better one. It's seeming to work very well. I think it's very successful. We have 2 part-time people right now, but even when they're not getting an agreement that day, people are calling back and asking to go back to them later. People are saying, well, we didn't resolve everything, but we resolved this one issue, or we were able to talk for the first time. And it's progress, and it's really helping these cases that are about children. So what we're asking for is one more person, another $35,000. That is absolutely budget neutral. Our contract with the mediation office is $75,000. As of last month, we billed $70,000 because when we refer a case to mediation, we charge the litigants $250. So right now, we're actually going to be, by the end of the year, on the $75,000, we'll be ahead of the game. So there's not going to be any cost to the county for this additional mediator, but it's going to be hugely successful to the lives of the people in Cuyahoga County who come to our court. The other thing that we're looking for is some funds for scanning. We will use the county scanning facilities, but we need a body to organize the paperwork. One of the things that we have been working on globally that is mandated by the Supreme Court is a continuation of operation plan. That is, if there is a crisis, and there have been many crises in many courthouses around the state in the last year or two, roofs caving in, flooding, firebombing. If there was some sort of a crisis and we had to go off-site, we would need to be able to access our records. Most of our records are in hard copy. So what we want to do is start scanning everything so that, number one, it's a storage issue. We don't have a fire hazard. We don't have a ridiculous amount of things in storage. And we have access to them somewhere in the bunker if we need them, if we're off-site. So this is, I think, a fairly reasonable thing. But we need a body to do it for us. We need somebody to organize the things to be scanned because I don't have another person who can do that. Everybody is working already full capacity. There just aren't enough people for what we do and what we need. The other thing is that even if you look at our numbers and are they high or are they low, what I would tell you is that we have had an explosion of pro se filings that are people, because of the economy, who are not hiring attorneys. There's a huge increase in that. What the numbers don't show you is how many people on the other side don't have an attorney. All our pro se numbers show you that we track are how many plaintiffs, movements are pro ses. They don't show you how many defendants are pro ses, and I would tell you that it's a huge amount. And when you have at least one, or even worse, 2 parties coming into a case in our court, emotionally laden, neither one represented, it takes our people hours to deal with them. And it's why we need mediators. It's why we need more bodies. It's why even if our numbers look a little bit lower, they're not really lower because everything we do is a struggle and is taking a huge amount of time. And we're trying to be as patient as we can. And as I said, we are here to help families restructure as compassionately as possible. And every person that works at the court believes that and is working toward that goal. Do you have any questions?
Questions by my colleagues? Council President Conley.
Just as an aside, you talk about this records. Our whole problem with record retention in the county is huge. In a perfect world, we should be able to hire somebody just to deal with records in all of the courts and all of the buildings. All you have to do is walk down the basement of the Lakeside Courthouse.
It's terrible. Because we have ProWare and Probate Court does and Common Pleas Court does, we have been talking to them jointly about backing everything up and having an off-site storage place, and we're working on a contract for that so that we don't have files everywhere and we don't have all this paperwork. And understand, too, that our stuff is confidential as well, so we really need protection for these papers, and we're making sure that everybody in our court now is entering their product. If it's a magistrate, it's their decision. If it's a judge, it's their judgment entry. If it's the social workers, it's their recommendation. They're all entering it in the computer under our case management system, which is controlled by ProWare, so that everything is backed up and we will have the ability to access it should there be a catastrophe. And I think that's a huge thing. We're in the process of planning that. We've been working on it, and I think it's a very, very positive thing for the county. Again, as I said, our issues are people and technology. We need the technology. We need computers. When I come here and say this that this is our budget, I can't say to you that I won't come back halfway through next year and say, we're in desperate need of XYZ computers or something. We might. But we're working now with Common Police Court to take some of their older computers as they're getting new ones under a grant so that we don't have to buy any more than we've already purchased. But still half of our people have computers that are 7 years old.
Right. My question is that the budget that we got from the county executive has a total of $6,725,866. And the amount that you're asking is $6,771,102. So it's an additional $45,000
Correct.
that you're
Correct.
asking over
At
and
this
above
point,
what
right.
we were told by
That's
the
right.
county executive. Okay.
Right. Okay.
Thank you.
Judge, I have one question about the mediator request.
Sure.
I see it is to be done by contract as opposed to hiring somebody on staff.
Right.
And my question is, how do we know that we would not enter into this contract and then not have enough cases that require mediation for us to make good use of the money?
Well, what we're doing, we have a local rule for the mediation, and that rule is that every divorce case that is filed that has children is automatically referred to mediation unless they come to the first pretrial with a parenting plan intact. So that means virtually everyone is referred to mediation. Post-decree, what we're doing right now is on an as-needed basis. The magistrates are vetting the case to see if they think it should be sent and talking to the people. So we're not sending every post-decree case. So we're not going to run out of cases that need to be mediated. In fact, one of the two contract mediators moved out of state, so we had even a month where we lost a mediator, and Susan herself has been coming and mediating for the last 3 months to keep us going. We're probably running 45 days behind right now, and our plan is to be 30 days. So with the third person, even if we don't add more cases, we will get it done sooner, and that's hugely important because one of the things that happens in our cases early on is that bad things go wrong and people get entrenched and they become positional. And the sooner you can get them to the table and talking and cure some of the ills, have the child support paid, have the children visiting, you can put a lot of fires out. So, I guarantee you that we have the numbers to do more people. And these are part-time mediators, they're not full-time. And again, that's an economy issue. Because if we're paying someone for 40 hours, there's no way anybody who's done a mediation would know that you can't do 3 a day. It's just physically, emotionally impossible. So 2 a day is what a part-time mediator can do. And so we're actually, we're maximizing their hours at the court. They're mediating almost all the time and writing the few hours that they're left, rather than paying somebody full-time with benefits. So we're not paying these people benefits. We're having them be part-time. What it'll mean is probably that Susan will do less at our court, she's the supervisor. She shouldn't be at our court filling in. And she has been doing that for several months. And to a great job, but it's not, her job should be to supervise.
When we enter into these contracts, is it a certain amount of money for a year's contract, or are they paid according to how many mediations are performed?
It's just a flat contract, and it includes the supervision by Susan as well as the 3 people. Well, it would be 2 people now, 3 people if we get the additional one. 20 hours a week, and we have a scheduler that's a person who works at the court who manages their schedules, and they pick their hours. We have office space for them. But as I said, the new filings, contested cases with children, we have plenty to send, and all of the post-decree things. And we could expand the program and do support or property division or other things using the mediator, but we wanted to start small and get it right and then expand.
Okay, other questions?
Mr. Chairman?
Germana and then Simon.
Reading from the pass out, it's saying that the third mediator is revenue neutral.
Right. That's what
So-
I'm saying. We've already billed $70,000 as of September on the $75,000 contract this year because we are putting on an order for $250 per case that we refer that actually goes to mediation. So that's getting billed through the clerk and hopefully collected at the end of the case. So if we're at 70 by September with 2 mediators, once we pick up the third mediator, we'll be doing more and we should be billing more. And I think the third one probably would be free at this point even because we've already paid the contract by September.
Okay, I just think when you have something that's revenue neutral,
The
it
oth-
makes the decision a lot
It's
lot
easier,
easier.
yes.
Sure. The other thing about our budget is that $3 million of our budget is collected from the federal government for child support enforcement. So that money gets paid back, so it's not really, it sounds like it's your money, but it's not. Another $1 million is billed through our fees that collected by the clerk and goes into the general revenue fund. So our budget really that's out of pocket to the county is 3 out of the 7, not 7 out of the 7.
Ms. Simon?
Thank you, Mr. Chair. To the administrative judge, I have a unique perspective on the court because I've spent most of my practice in domestic relations court. And as a practitioner, what I've seen is that the FCS department is totally backlogged now. I think we're looking at 4 to 6 months before report is
Our FCS
forthcoming.
department is the department that everyone took the buyout except the supervisor. That's family conciliation. That's our social workers who do custody evaluations for us. So we hired one person last year, one person during the ERIP. So we have 2 people right now plus the supervisor, so it's 3. They've been backed up because we had one full-time and one supervisor who's a full-time, and then we added the new person who had to get up to speed. So, that's another place we need a body. But what we're now starting to find is that the mediation cases are settling the easier ones, and now the FCS, the social workers, are only getting the harder ones. I think that the timing will be okay, but our director is retiring at the end of this month, and we've hired a new director. So, there's always going to be these kinds of things that slow us down. Our normal requirement is 90 days, so 3 months for the custody evaluation that goes on, the evaluation from the social workers. That's to get interviews with the parents a couple times, with the children, with collateral sources, and to write it up. We were asking 120 days for a while because we were down to 1 or 2 people. Over the last 2 years, there was either 1 person, 2 people. Now there's 3. Now we're going to lose 1 and gain 1. Luckily, the person we've hired as the new director has been doing this at juvenile court, the exact same thing. So I don't think there's going to be any learning curve there. So that's excellent.
Thank you, Judge, because that's essential to the expeditious progression of these DR cases is to make sure that we have that.
I'd be happy to have another social worker if you would like to fund that.
But what you said is part of my question. If the mediators are siphoning off the easier cases and then lessening the load of FCS, then maybe the additional mediator would make sense, especially for the pro se litigants.
It's a huge issue. The time that it takes to explain it. If you understand a client going to a lawyer spends hours talking to the lawyer before they get to court. These people come to court with no information. They don't understand the language. And I don't mean English. They just don't understand the law language, and a lot of them don't understand English, actually. We have a huge problem with foreign-speaking people and interpreters, and it's very time-consuming, and we are trying to give everybody access to justice that they deserve.
Okay, anything else?
Thank
Okay.
you very much.
Thank you very much.
Thank you.
We will now call forward Justice Thomas O'Malley, Juvenile Court.
Thank you, Mr. Chairman.
Welcome to the committee.
Thank you. Members of council, to say it's a new day at juvenile court is an understatement. We've been in our new facility at 9300 Quincy for, this is another 10 minutes, it'll be 15 days. We are extremely excited and proud to have this beautiful facility, and the citizens of Cuyahoga County should be thrilled and excited to have such a beautiful facility in their community. We are extremely thankful to Jeff Mowry and the IT team, as well as the Public Works Department, for the amount of time and talent they gave for our move and our transition. I would like publicly to thank Sunny Simon for her insight and help during the transition. And I would also like to thank Sheriff Reed. Without his force and his help, we would not have been able to move like we did. For a number of years, juvenile court has done multiple things to spend wisely, decrease costs, and increase revenue. I'm going to highlight some of those. We accepted the early retirement incentive program, and we reduced our staff by 87, which caused us to reorganize our probation department, our clerk's office, and our IT department. We virtually eliminated the use of overtime in our detention center. Overtime once cost the county over $1 million a year. In 2009, the average daily population in our detention center, your detention center, was 172. Every morning I get a text message as to what the head count is in the detention center, and today was 116. We are constantly seeking alternatives to incarceration, but these alternatives are not free. We signed on to the Annie Casey, Ann, middle initial E, Casey Foundation, which is the Juvenile Detention Alternatives Initiative. It's a national initiative. This will assist us in using the detention facility in a fiscally prudent manner, yet help maintain the fragile balance between public safety and the best practices for youth. Last fiscal year, we sent less than 180 youth to the Ohio Department of Youth Services. The last time that occurred was 1955, and that has to do with the hard work of the judges, the magistrates, and the probation department. Anyone that is going to be committed or a potential commitment to the Ohio Department of Youth Services, except for sex offenders and individuals that have gun specifications, have to come through my office. I head a committee. We call it the Ohio Department of Youth Services Review Committee. It's made up of many of the people that have accompanied me today. Pursuant to law, we make every effort to choose the best and least restrictive dispositions for juveniles. This means more community-based programming, placements, and interventions which work to prevent youth from entering the more costly, less effective, secure facilities. We've started a traffic violations bureau, waiver bureau, that allowed 569 traffic citations to be waived last year, netting $73,000 in revenue. Last year, we caused $3.2 million to be added to the county general fund. We raised $850,000 from our special revenue accounts, secured $4.1 million in grants. In other words, we raised $8.1 million for the county and our court. We project these revenues to be $10.3 million this year. I was thrilled when Chief of Staff Nani's sent a letter inviting us to be here before council. I've been involved in the budget process before. Somewhere along the line, the budget process and what is supposed to happen got derailed, which caused juvenile court, and I can't speak for the other divisions, it caused juvenile court to be micromanaged to the umpteenth degree. Ohio Revised Code Section 2151 states that the juvenile judge shall annually, doesn't say may, says the judge shall annually submit a written request for appropriation to the Board of County Commissioners. One can only assume it's county council and the county executive, that shall set forth estimated administrative expenses for the juvenile court that the judge considers reasonable and necessary for the operation of the court. We have done that. We've supplied that to you. To think that we won't have some additional expenses with our new facility would be foolish. They arise every day. Some of the examples I can give you, clocks. We came from a 167,000 square foot facility to a 670,000 square foot facility, and somewhere along the line, the planning and what we were going to need, just you couldn't even, no one could anticipate it. From chair pads underneath your desk, to the doors not working. This morning when I got to work, pulled in the garage, had to walk back out of the garage around to the front door and go through the metal detector. Just little things that are going to arise as we go along. I never profess to know everything, so I have brought with me a slew of individuals. We have Marita Kavalak, our court administrator, Mr. Dana Chavers, Director of Court Services, Len Monks, Superintendent of the Detention Center, Timothy McDevitt, Director of Probation, Nick Valukovic and Joe Talatnik are our business administrators. Karen Littman is our Deputy Director of Grants Management, and Mark Major is our Chief Staff Attorney. I would like to take this time to thank you for your attention and all your help in seeing this project through. I know that our juvenile court started many years ago before any of us, including myself, were part of the system. And we, the folks that are with me today, and the 502 other employees that are out at 9300 Quincy would like to thank you, and I would take any questions that anyone has.
Council President Connolly.
Thank you for your presentation. I'm not sure if my question relates to the specific budget items that you have here, but over the course of the 9-10 months that we've been here, we're constantly getting these requests for these out-of-state residential facilities and facilities where children are shipped. And I know it's been a particular concern of mine that we're not only sending dollars out of the county, but we're sending our children out of the county, but out of the state. And I know there's a great many of the children go to the facility outside of Philadelphia, and I'm sure it's a very, very fine facility, but these are dollars that are going out of our state, and our children are going all the way to Philadelphia, and it's very hard for family and relatives to go to visit them. And plus, we got to ship them there and ship them back. And I was just curious as to if there's some help that we could get in terms of reducing those costs.
Are we talking, what's the name?
I'd be happy to respond. Glenn Mills.
Glenn Mills. Glenn Mills in particular, but some of the other ones are outside of the state and outside of our county.
I'm pretty certain that we only have one out-of-state contract, and that is with Glenn Mills.
And I know there are some particular children that have very particular needs that you ship them out of state because of very unique circumstances, and those are fairly rare. But I know you have a tremendous number of children going to Glenn Mills.
Well, and we are using them really for two reasons. One, there is no similar facility anyplace else in the Midwest that offers the same kind of programming that Glenn Mills does. The second reason we do is their per diem rate is the lowest of every single solitary residential provider we use. If somebody in this region would choose to adopt the same sort of mode and curriculum, it's basically known to be a career trades vocational kind of school that also offers social services programming. And it's meant for delinquent males who do have a lot of needs. If anybody else would attempt to put together such an enterprise and also be as cost-effective as Glenn Mills is, the court would absolutely positively consider entering into a contract. Those are the two primary reasons that we come to now you annually seeking a contract with Glenn Mills Academy.
Okay, I know Mr. Gallagher and I talked about it a great deal. It's just a lot of dollars going out of our state. And how do these children get to connect with their parents? I mean, you're all the way over there. It's a long drive to Philadelphia. Do the parents get to visit them? Do they get to see them? Do you have arrangements to go and visit them?
Want to get some more details on? Thank you.
Mr. McDevitt is the Director of Probation Services in charge of that. Go ahead, Tim.
Thank you. We have about 20 kids, I think, currently at Glenn Mills out of the probably more than 1,700 youth we have on probation and in residential placement. And it is it is a distance, and that does present a difficulty. But Glenn Mills does phone counseling with the youth and parent at least once a week. They also have opportunities, families to visit, but I will tell you, it is rare. It's difficult to get there. And the kids also are able to come home on home pass at least 3 times a year.
I mean, how do you get them home? On the bus? Do you send somebody over
Glenn
there?
Glenn Mills, in their per diem, they pay for all transportation. So when we have a kid who's going to be placed at Glenn Mills comes and gets them. When they have a home pass, it's usually around the holidays, 4th of July, Christmas, Easter. Glenn Mills charters a bus and brings kids to Pittsburgh and to Cleveland, the Columbus area, a number of cities throughout the Midwest.
Okay, thank you.
Councilman Gallagher.
A follow-up. It was reported, and we all know about reporters, but the reports were that one judge in particular was sending kids there with no developed criteria as to how that judge was picking those kids.
Yeah,
Is that still going on?
Well, I think all of our judges have sent kids to Glenn Mills. I couldn't tell you how many each of the judges have at the facility currently, but I think all of our judges have. And the criteria that we're looking for a kid with Glenn Mills is, as Ms. Kavalak mentioned, it's a kid who is older, who has some vocational, educational needs, it's usually a more aggressive kid, a kid with a higher level felony. It's a kid that many of our local facilities in the past have had a hard time dealing with. And Glen Mills deals with those kids very, very effectively.
Well, you do it for a living, I don't, but it jumps off the paper at you when you look at it. And could you get me a breakdown on the judges and who sends them there?
Sure.
I'm shocked to say that you only have 20 kids there, because I know the last appropriation for Glen Mills was like $350,000. I mean, they're very, very large appropriations. So when you tell me there's only 20 kids there for, it seems to me it was $350,000 was the last appropriation.
That sounds right. And 20 kids there today and tomorrow. The average daily population, well, not average daily population, but the population today is 20. The average daily population at Glen Mills for the past year has fluctuated probably between 15 and 20.
And my other question was that we got a request for an appropriation within the last month, and it seems to me that you would have known a long time ago that you knew you were over your budget, and you came in to us for a request for this extra money under suspension of the rules, where we had to rule on it like right away, or vote on it right away, and you knew months before that you were over your budget. And I mean, I know we've got to give you the money, but it seems to me that we need to have these more timely. When you know you're going to be over your budget, we need to know more timely so that we're not passing everything under suspension of the rules, because then we don't have an opportunity to send them to committees.
It was not a request for an increase in dollars.
It's not an increase, but I'm saying when you send it to us and you want it passed the same day under suspension of the rules, we need to have that in advance. I mean, you just didn't find out yesterday that you owe these people all this money.
The residential placement program, Joe, correct me, is it $6 million total between partnership? Almost $6 million. The funding is between two different index codes. One is our partnership, and the other is in the regular probation, health and human services funds. Now, when we were contracting, we never contracted with these folks before, but due to the dollar amounts and all the ordinances that council has come up with, we have contracted with them. However, with our jurists and how they place these kids in these different residential placement facilities, there's no way to tell where we're going to stick these kids. So we came out with a first plan of a number. And then after a while, when we got our numbers back, we saw which placement providers were spending more than the others. So we had to do a shift of these funds. So Councilperson Conley, when you say there was an additional request, the additional request was funded from another residential placement provider where these monies would shift. Did I clarify anything?
Well, what I'll do is the next time we have one, then we'll bring it up, and it won't be passed under suspension of the rules, and you're going to have to come in and explain it. And I think I voiced the sentiment of most people on council that we're getting these requests and we're not getting explanations for them.
We have actually commenced conversations with the county executive and with Mr. Cologne specifically. We think we do a very, very fine job projecting overall what our placement and treatment dollar needs actually are. To embrace best practices, what we need to do is have multiple providers who can customize their programming for every individual juvenile. On January 1st, we can pretty well know we're going to need $6 million because we can project the quantity of cases and who's going to have needs. We can't project, though, if they are going to have sex offender treatment needs, if they are going to have other profound mental health needs. We divvy up the money between the various contracts, between the various providers, but it's very, very difficult to know for sure we're going to send 3 women to your place, 6 men to your place, 2 people to your place. Having to have an individual contract with each of them is very inefficient and very, very cumbersome. The conversations we have had are, we should have basically like a pool of money, contractual obligations between the county and the individual agencies, but we shouldn't have to be moving the money around back and forth depending on who is in what place for how long. I'm not sure if I'm explaining this well, but our system has made it inefficient, the way we have had to have these contracts, and then we're constantly coming to you with amendments. We have to come up with a better way. The conversations have already commenced. The good news about all of this, though, is we have proven that we're really doing the best possible job on behalf of the juveniles who come before the court. We do a tremendous in-depth assessment of their needs. We make sure that we have the most appropriate and best suited program to refer them to, and that's exactly what we're doing. So now we just have to figure out how to ease the red tape that we have imposed on ourselves with the obligations we have made with the various providers.
Mr. Chair.
Ms. Simon?
As a follow-up, I think Justice Affairs Committee has managed to hear all of these requests. So every single one has gone to committee, and we've been able to look at the requests. I've accommodated the needs and changes that happen at the court. So I have a question about the handout. Can I proceed? Thank you. So there's an additional amount pursuant to 2151.10 that the...
Correct.
Okay, and that's highlighted here, what the differential is. Okay. I want to talk about a minute of the diversion program that the juvenile court has had in place for several years, and I understand that the budget for that has almost been cut to nothing. Can you explain, Judge, a little bit about that?
I believe it was 2009, we had over 400,000, I think it was 419 for our diversion program. And the diversion programs are throughout the community. It's to head them off at the pass, if you will, to first offenders. Our diversion program budget was cut to, I think it's 213,000 right now. We had some of the suburbs get out because they couldn't afford to do it. We also have what they call the CUP, the Court Unruly Program. Now, the difference between diversion and CUP is that the diversion programs won't take unrulies. The last time our CUP program was funded was 2007. Although we use it, we're good with our money as far as what we do with it. But the diversion program is very important, as you have brought up, in that if we can divert or prevent cases from coming official, if you will, it saves the county a tremendous amount of money.
Mr. Chair, to the judge, this is one program consistent with the executive's initiative for community policing that I would like council to consider enhancing, because it is on the front end, and in the communities are in desperate need of having some assistance to address the youth that are creating a lot of safety issues and problems in the neighborhoods, which has an effect that ripples out with people moving out of the county, people moving out of their cities, and being afraid to live in neighborhoods in Cuyahoga County. And then these youth end up as first offenders. Once they get into the system, we've heard it repeatedly that we're just magnifying and just creating another problem. So I would like council, if we can, to look at enhancing this diversion program and the CUP program, and maybe if the judge can give us detail, or the administration, of these programs and where they've been and how the cuts will affect the municipalities. We can take a look at that, because I'll tell you, this is the very front line, our juveniles. If we can get them at the beginning, they're not going to end up in the system where we're looking at reentry and we're looking at the housing issues. This is where it starts, and the ripple effect, I can't begin to articulate how important it is to enable our residents to feel safe. And when I out there every day. That's what residents are asking for, and I think that's why our executive had put some money into the community policing initiative, and this is the sister component to that. And I think actually it's more bang for the buck when you're looking at juveniles.
Councilman Gallagher?
The diversion program, that's where the attorneys would hear the cases out in the.
Correct. Diversion programs are volunteers, but the diversion programs are for first offenders, delinquencies, which are criminal cases.
Okay. You know, it's about time that everybody stops laying on the county for every nickel and dime. And some of these communities have to step up. And I know things are tough in the cities, but they're even tougher in the county. So maybe we need to bring some of these cities in and have a little discussion with them, especially, and I would assume, and I'm just assuming Cleveland's a big one?
Cleveland is.
And how much money do they put into this?
They don't get anything from us.
No, I mean, how many do they put in? I mean, they do their own? What cities are having trouble?
South Euclid dropped out. What we do is we have a diversion officer, and she has a breakdown, and we sit down and figure out how much each community is going to get based on how much they've used in the past. And then when they cut it from over 400,000 to 200, we had to say, like the Lakewoods, the Parmas, the Euclid, the bigger suburbs obviously use more. But I had the police chief from South Euclid call me and say, you know, we can't, whether if the amount was 5,000 or 10,000 we're going to give him, he said he can't do it. So then we divided it up amongst the other suburbs that wanted to still participate. But they do fund, there is some dollar amounts that they must absorb on their end. Because what we give them, there is no way they could do their diversion program with the limited funds that we provide to them.
Okay.
I just like to support what Ms. Simon says about the diversion programs. They're so important, and they haven't been as popular or available in Cleveland and the inner ring suburbs, so you end up with more minority kids in the criminal justice system. And so you have a lot of the kids in the far suburbs that are fortunate enough to get into these diversion programs, which are really good. And I'd like to be able to see that diversion program all over the county. So I don't know if we could have hearings in the Justice Affairs Committee and see what we could do to work with you to get this, because it's really important. If you can keep those kids away from, you know, your system on the front end. And I wouldn't have seen them in municipal court and on down the line in the grand jury.
That's right. And Madam President,
Yeah.
Madam President, what we're going to be looking at Justice Affairs is how we can consolidate municipalities to maximize the dollars that would be coming hopefully from the county to merge them. Richmond Heights, Euclid, we've got, you know, a small community and a very large community. So in answer to Councilman Gallagher's question about municipalities stepping up, yes, we're going to look at trying to have them share services. But the District 11, Euclid, South Euclid, Richmond Heights, Cleveland Heights is an inner ring, Shaker perhaps, the dynamic there is much different, I would imagine, from your district, where you don't have the kind of inner ring concentrated issue with youth that we've been experiencing and lost great amount of population because of that. So it's a benefit to the county to have these services. The municipalities in the inner suburbs are bare bones beyond less. I think the county's in better shape, and we have to look at the benefit of the county and have the city step up to start to share. I think that's the first step.
And our statistics, and we keep excellent statistics, will break down by suburb how many individuals, how many youth use the diversion program, how many have gone through it.
Full disclosure, I used to serve many years ago. I was one of the first volunteer juvenile magistrates, so I can tell you firsthand the impact it has on the kids, because you have to bring the parents in, and everybody needs to participate in this, and it just avoids down the road, you know, a whole life of being in the system, which we pay for. So it's not a question of who's going to pay. We all are paying at the end if we don't divert.
Judge, could you get us a breakdown
Absolutely.
of how many use the diversion program by community and get that to Trevor McAleer, who's our budget person?
Absolutely.
And I would add that I strongly share that this is a very important area that we need to try to do more with, and though I support that effort.
When I came in, that was on my wish list, but.
And Judge, I have one question, which is that that your proposal on this handout here is for a total of 54,059,000, and the executive's all funds proposal in 2012 is for $53,683,745, a difference of roughly $400,000. And my question is if you can clarify what the items of difference are.
I compared that cost, and I compared it to the requested 2012 agency budget. But the majority of the difference is in fringes. When I received the brass documents and did our need, there's a stipulation in that packet that whatever council and the executive come up with as far as the healthcare costs, those are the costs that they will be. At least $200,000 is in that, and the only additions we made to that budget was $200 for 375 FTEs for additional supplies and furniture and equipment. Total of $75,000.
So you had $75,000, and that was for what again?
Supplies, furniture and equipment in the new building, the clocks, the chair mats, anything else that was not planned for. And we went with whatever was else in the budget. And at first glance, after I got the documents back from OBM, because our brass system is not down, we don't have the application on our new computers, Joe and myself, I noticed that the big difference was in fringes. Yeah, the fringes were reduced in the brass documents, and we didn't do that on ours, and that's totally fine. Whatever those costs are, that's what they will be. And then we had a $31,000 request on YFCP for some salary overtime issues that were reduced in our budget.
31,000.
Correct.
Okay. Overtime.
And I just found the other 140,000, which is the difference between the requested budget. 300 and some thousand is in fringes.
Fringes, okay.
Benefits.
Okay, thank you.
Hey, Mr.
Any-
Chair, I have a question.
Councilman Greenspan.
I'm sorry, I was trying to figure something out. I apologize if you've already answered this question. So the 53 million that was presented here in the budget, how much input did you have in that number? The 53 that's in the budget, 53, 683, 745.
We had conferred with folks with our analysts in OBM, and basically it was a good number, except for the 31,000 and a few other items we came up with.
And when was that confirmed? Or when did that?
Our budget, or?
Well, whenever you had agreed to it, whenever this number was compiled.
A week ago? Friday?
Friday.
Okay, thank you.
Okay, anything else?
Thank you.
Okay, thank you. We're going to need to have OBM and the juvenile court confer and confirm exactly what our differences in calculation and what our actual decision items that we have to deal with. So we'll work on that. Our final presenter for this afternoon is Judge Anthony J. Russo. We appreciate your patience, and Judge Russo will be presenting on the probate court.
Good afternoon, or should I say good evening, Council President Connolly,
It's still afternoon, it's not yet 5 o'clock.
Chairman Miller, Mr. Cologne, and members of council. First of all, before I get started, I'd like to address the other judges. I appreciate that you're here to show your support as we all are together, but I realize you've been here all afternoon, so don't feel like you need to stay for this presentation. If you want to go, please feel free to go. On behalf of myself and my colleague, Judge Laura Gallagher, thank you for the opportunity today to discuss the needs of the probate court and the vital functions that we provide to the citizens of Cuyahoga County. The probate court will have more than 11,000 case filings by the end of this year. This includes estates, trusts, guardianships for minors, also guardianships for adults who can no longer care for themselves. These cases are similar to what Judge Palos mentioned. They're continuing jurisdiction cases where adults that are under guardianship, the court is constantly supervising expenditures and approving final accounts. We also handle psychiatric commitments and adoptions. Our civil filings also include will contests, concealment of assets, determination of heirs, land appropriation proceedings, and land sales. In addition, we issue almost 7,000 marriage licenses each year, and we perform over 350 marriage ceremonies. The marriage ceremonies are a completely new service recently provided by the court. It's at no additional expense to the county, and it also generates additional court costs which go into the general fund. Probate court strives for excellence in performance, serving our citizens with courtesy, competency, and respect. We're constantly searching for more effective ways to perform our necessary functions, which are mandated by the Ohio Constitution and the Ohio Revised Code. We are certainly sensitive to the challenges of the present economic climate and the strain it places on the financial resources of Cuyahoga County government. However, as you probably already know, court costs and court fees alone cannot completely support court funding. Courts were never meant to be self-sustaining systems. Access to the justice system and court services that are provided cannot depend solely on user fees or the citizen's ability to pay. However, the probate court is contributing over $1.5 million in court costs towards our county budget through the general fund each year. Our court has always made every effort to work closely and constructively with the county government in order to find mutually agreeable ways to meet our necessary expenses. I'm cutting out half of my presentation here so we can move it along a little bit. After taking office in 2009, I began a deliberate methodical review of the court's operation and budget. My goal has been to implement policies and procedures which are necessary to meet all of our constitutional and statutory mandates, while at the same time increasing revenues, maximizing efficiency, and reducing expenses. We believe the probate court has been extremely successful in this regard. Our focus in 2011 has been on the conversion of our 14-year-old case management system to one which we believe will allow us to process and manage our cases with greater speed and efficiency. It will also allow our citizens to have greater access to our court while reducing their time commitment and inconvenience. The total cost of the new court case management system is being paid from the probate court's own computer fund, so it's at no cost to the out of the general fund for that. Since I became presiding judge in 2009, the court has lost a total of 19 full-time employees who participated in the ERIP program. So we went from 92 employees to 73 employees now. That's a loss of more than 20% of our personnel. Although the decision to participate in the ERIP program was done before I got there, we have made every reasonable effort to minimize its adverse effect on the services provided by the court. We have conducted extensive cross-training of all of our deputy clerks in order to enable them to perform multiple functions in the court, thereby increasing efficiency. While this has been a big help, to be honest with you, we are still understaffed. For example, we have not had a full-time staff attorney for the past year. Our staff attorney was promoted to a magistrate's position and also the director of our computer services. So for the past year, we have, by we, it's our court is 2 judges. We don't even have a law clerk or a staff attorney. We've been using part-time externs from Cleveland Marshall College of Law that come in and serve as our law clerks. Now, these are only law students. They're not even, real attorneys. And as you know, in most of the courts, judges have at least one staff attorney, sometimes two. So it's been very difficult to work without a full-time staff attorney. On September 1st, we began offering mediation services to litigants. Again, this is at no additional cost to the county. This alternative to traditional litigation allows parties to participate directly in resolving their own disputes rather than having the court conduct a trial. This generally serves to unclog the court's docket and move all cases through the system more quickly and efficiently. All of our magistrates have also received mediation training through the Ohio Supreme Court in order to expand their mediation skills and thereby assume additional responsibilities. In reviewing other efficiencies that could produce savings, we implemented a process to tighten the collection of court fees and costs. Previously, many of these fees were not required to be posted prior to filing, which then allowed significant revenue to go uncollected. We also performed a statewide review of other probate courts to assess their fee structure. A complete revision of our court costs with parameters dictated by the Ohio Revised Code was then implemented. On August 25th of 2010, we implemented a new fee structure, which resulted in a 60% increase in fees collected by the probate court and submitted to the general fund. This translates to an additional $577,000 in probate court cost monies that are going into the general fund in 2011. In other words, instead of probate court giving the general fund $955,000, we're giving the general fund $1.5 million. We're respectfully requesting that you approve our very reasonable budget request for the year 2010. And I want to thank you for your time and attention this afternoon. If you have any questions, I'd be glad to try to answer them for you. I have with me, I'm sorry I didn't introduce, our court administrator, Magistrate John Homelak.
Questions by my colleagues? Councilman Greenspan and then Gallagher.
Great, thank you. Based on the information you gave us, it might assume that what you're asking for is 5.9 million. Is that?
That's correct.
Then,
now,
yes, go ahead, sir.
That was the same amount it was for different things, but that's the same of our total budget for 2011. So it's not really an increase over 2011.
Okay, there's somebody from budget management here. On page V30, or IV30, why is the number 6.3 million for 2012 and the 2011 number 7.9 million if they're supposed to be the same 5.9?
It also doesn't necessarily include the benefits portion, which has to be calculated by Office of Management and Budget.
So this 5.9 then is not
That does not include that.
Okay.
Number for the benefits portion.
Okay, then if the number, okay, so what you're saying is that excluding that benefits load, the 5.9 million is the base for both 11 and 12. And then the delta between the 2011 number and that's a $1.5 million difference.
No.
I'm sorry, no.
All right, I am confused. What we're showing here, the all funds number.
You're showing, okay, I'm looking at the general fund commitment. You're adding in the other funds.
Correct.
Those are the other funds that are from the court's restricted fund that the court does make contribution from, including indigent guardianship fund,
Okay.
The special projects fund, the mediation fund. So those numbers are being added into that line, but we're just dealing with the first line. So the first line of the base budget was 5.705, and we're at 5.9.
Those numbers we felt were revenue neutral because we're reimbursing the county.
Now I see.
In other words,
just so you understand, like for instance, from the dispute resolution fund, our proposal is to contribute 26,000. From the special projects fund, we're contributing 35,000. From the computer fund, we're contributing just under 115,000, and from the indigent guardianship fund, which is reimbursed for the Department of Senior and Adult Services, we're projecting to contribute 160,000 in calendar year 2012.
Thank you, I understand that. So what we're saying here is this 5.7 million in 2012 that was in in our package. The number you're now asking for is 5.9 million.
Correct, and the difference, I believe, is 194,000, but when you take away again, the capital outlay, I believe, was already in there, so when you remove that 28,000, and you also consider the 26,000 contribution for the mediation services, I believe the net difference is 140,000.
That's correct.
Okay, and that 140, and I see that, so you're asking for an additional 140,000.
That's correct.
Okay, great. All right, thank you.
Thank you. Anything else?
Just a quick question on these weddings. Who's actually performing the weddings at probate court?
Myself and
you
Judge
are?
Gallagher, yeah.
Do you have a
We're the-
special
We're the only
place,
judges there.
What do you guys do in the chambers?
Right in the courtroom, we do them.
Great.
Yeah, by
And on
appointment.
behalf of the Cleveland Municipal Court judges, we thank you.
Well, most of them wind up over there, but we do a fair amount.
I
of them.
think Cleveland Municipal Court only does them for people who live in the city of Cleveland. When I was there,
okay.
we were doing weddings for the whole county, and we decided that it made no sense for us to be doing the weddings for Lakewood and Parma and, send them to the judges where these people live. So I think we were just doing it for Cleveland.
Yeah, they keep us busy.
I'm sorry, Mr. Chair, I have one more
Of course, you
question.
also increased the business for domestic relations.
I was just going to say, which, as you know, is where I used to be. So I used to divorce them, and now I marry them, and it's just it's a vicious cycle.
You get them coming and going.
Councilman Greenspan.
One question, when did you submit your proposed budget to the Office of Budget Management?
We had our meeting with the Office of Budget several weeks ago, and we only received their base budget on Friday.
I was going to say, we submitted it at the time of the meeting. Mr. Cologne was not present, but we met with his assistant, and I think that was about 3 weeks ago.
So thank you. So between the time when you submitted it to when you received it, there was no discussion?
No.
Oh, okay, very good, thank you.
Councilman Gallagher.
Judge, this is a complete aside, and for my wife, you have some friends over at the Metro Parks, the bike paths are a mess. So, Judge, first, even I know
Where
people
at?
that are asking for more.
Where at?
Strongsville.
Strongsville?
And that, actually, the roads are going into North Railton, just horrible.
I'll get right on that.
But just for her, not me. I mean,
Anything else?
Thank you very much
Okay,
for your time.
thank you very much. Is there any miscellaneous business? Has anyone signed in for public comment?
No, Mr. Chair, no one has signed in.
We are going to resume these hearings next Monday at 1 o'clock. It'll be from 1 to 6. It will be a long session. Is there a motion to adjourn? All in favor, say aye. Aye. We're adjourned.
I don't care what they say about it.